Welcome to the Combative Nerds Podcast. Join us while we break balls and try to outwit each other at every turn while debating all things nerdom and trying to make sense of this world. Look, I'm not gonna lie, this is a Herculean task and I'm not sure we have enough brain power to do so. At the very least, we can laugh and offend each other through the process. Thanks for sharing your day with us. Now on to our show. Hey, what's going on? This is Raiderlance, and it is November 11th, 2022. It's going to be a solo little intro for this episode. So before we get started, I need you to like, subscribe, share this podcast, hell, even comment on our videos. We need all the support you can give. This is an important subject, and help us disseminate this information because we really feel like we're being even killed with the legal analysis on this subject. We're not trying to pick sides. We're just trying to explain the law. You can take it the way you want. So next thing is I have a cold, so my voice may sound a little off. You may hear a little coughs here and there. I do apologize. My whole family got RSV. So I hope everybody out there is safe, healthy, taking it a little seriously. I know masks have been stigmatized. Man, it might not be a bad idea to wear a mask every once in a while when you're around a bunch of people. You don't want to catch this shit. It's been miserable. So enough about that. Be healthy, especially during the holiday seasons, so you can spend time with your families, hopefully. Okay, so why am I doing this little intro? Well, if you got through episode 1, which I hope you did, that was about an hour-long legal analysis, and now you're jumping into this one, maybe you forgot. Maybe I can summarize a lot of it for you just to, help you along because we're going to jump in the middle of the conversation. So let's backtrack a little bit. 3 cases that deal with abortion at the federal level. You got the recent case that was decided, Dobbs. You got Planned Parenthood versus Casey, and you got Roe v. Wade. All right, so Dobbs is now, let's just call it the new precedent. That's what everybody's going to have to follow. What did the Dobbs decision conclude? All right, 3 main points. 1, the Constitution does not confer a right to abortion. 2, Roe v. Wade and Casey versus Planned Parenthood are overruled. 3, the authority to regulate abortion is returned to the people and their elected representative, meaning the individual states. So again, abortion is now unconstitutional at a federal level, which means each state can come up with their own rules, their own determination on whether abortion should be legal and whether there's any parameters to having that abortion. Now, again, I'm going to ask you guys, figure out your emotions, figure out your personal beliefs, whether it's religious, whether it's societal, or whether it's medical decision-making, or whether you feel it's murder, and I don't give a shit. For the purposes of this conversation, this is just facts. This is just law. This is analysis. You might not like it, but if you want to be logical and reasonable, you have to at least understand what the law is. Then argue with it. Then take it to the voting booth. Then talk to your congressperson. Right now, I don't give a crap about your feelings on this subject. I'm just going to go through the discussion. Now, at the end, me and FighterWizard talk a little bit about our feelings, but it's after we do the legal analysis. All right, so we went over the 3 holdings of the Dobbs case. So let's go through I guess you would say parts 1 and 2, the Supreme Court's analysis of the Dobbs case. So there's a 3-part analysis for them to overturn Casey and technically Roe v. Wade, but primarily Casey. So the Supreme Court looked at 3 things. 1, does the Constitution confer a right to abortion, whether explicitly or implicitly? Now, in part 1 of this podcast, the Supreme Court concluded there's no language at all, plain text in the Constitution, that gives a right to abortion. It's not there. So what the Roe v. Wade case did is they inferred the right to abortion within multiple different amendments, and they kind of hung their hat on the right to privacy. So it was challenged in Casey versus Planned Parenthood. And what that court did is they said, we agree with, the heart and soul of the decision, but we don't agree with the specifics. We don't agree with you can only do this in the first trimester, that in the second trimester, and such and so forth. So instead, what they said is there is a right to abortion, and it can be inferred in the 14th Amendment due process clause, specifically as a substantive due right. And we explain all this in part 1. If you want the minutia, go over there. Trying to just give it quick and thin so we can get to the 3rd part of the analysis. So first part of the analysis, whether the Constitution conferred a right to obtain an abortion explicitly, implicitly, the Dobbs court analysis showed that it does not. And it doesn't, guys. It is what it is. You can change it. You can do an amendment to the Constitution. But right now, is it constitutional? Not on the plain text. Second point, So if it's not in the plain text, the second part of the analysis is whether the right to obtain an abortion is rooted in the nation's history, tradition, and whether it is an essential component of ordered liberty in the 14th Amendment due process clause. Well, the court went through a long process of doing this analysis, and they said that it did not. It was not rooted in the 14th Amendment. There is no nation's history or tradition or laws supporting the right to abortion. So that was point 1 and 2. Here we're going to jump into the third part of the analysis, whether a right to obtain an abortion is part of a broader, entrenched right that is supported by other legal precedents. All right, so now we're going to jump into the old conversation I had with FighterWizard, and I hope you enjoy. At the end, we are going to talk about our opinions a little bit, but hopefully I delineate it. It's after we talk about the specific opinions from the different justices. So I hope you're doing well. Please feel free to comment whether you agree, disagree, but hopefully keep an even mind. We're just looking at the laws. We're not talking about opinions until we talk opinions at the end. All right, talk to you later. Bye. Okay, so now we get to the third point of the analysis. And this is where the court should consider whether a right to obtain an abortion is part of a broader entrenched right that is supported by other precedents. So, second part of the analysis, we're looking at histories and traditions, ordered liberty. Now we're looking at just a broad entrenched right that is supported by any other previous decisions. So now we're really going to widen our scope and see, hey, is this just a broad right that has been discussed? Well, the court concludes that the right to obtain an abortion cannot be justified as a component of such a right. Attempts to justify abortion through appeals to a broader right of autonomy and to define one's concept of existence prove too much. Those criteria are at a high level of generality and could license fundamental rights to illicit drug use, prostitution, and the like. So I'm going to stop here because, in my opinion, this is where the court kind of overextends. I'm not going to say judicial activism. I wouldn't go that far. But in this analysis, this is where the morals and the moral arguments of abortion come into play, right? When I've listened to pundits or proponents of pro-choice, it's always that people are being denied medical services and a woman has the right to determine what to do with her body. So they're making it a medical and a persona argument. Here, the Supreme Court makes it a moral argument. And so before I make these arguments, I just want you to understand I'm not making these arguments. So going back to what these justices did, they said abortion is not an entrenched right supported by other precedents. That's fine. Attempts to justify abortion through the appeals of the broader right and define the concept of existence prove too much. So here the judges are trying to distinguish, or you hear the term slippery slope. They're trying to make the argument that if you're saying you have a right to autonomy because of and define it under your concept of existence, then you too can also argue that you should be able to do drugs as much as you want. No one should be able to stop you. You can go to TJ hookers and Thai ladyboys, and you can do all these other things that the courts and the legal system would never approve of. So we're not going to go ahead and grant you that large of a brush to paint with when making these arguments of autonomy and the concept of existence. So here they talk about entrenched rights. Entrenched rights that are supported by other precedences are sharply distinguished from the abortion right, because the abortion is different in that it destroys what Roe termed as potential life and what the law challenged in this case as an unborn human being. None of the other precedences and decisions cited by Roe and Casey establish that the right to obtain an abortion is part of a broader entrenched right, involves a critical moral question posed by abortion. Because of that, those cases and precedences do not support the right to obtain abortion. So again, there is this moral argument. Sure, there are entrenched rights, but any entrenched rights, and we're going to go into this, they list about 3 or 4. Any of those entrenched rights that are supported by precedences, but are not explicitly stated in the Constitution, are not explicitly covered under order liberty, under the procedural due process clause or the substantive due process clause. Any other entrenched rights that are held by precedences, there's a difference between the two. And the difference is Roe v. Wade allows you to kill a baby. And that creates a critical moral question. The right to an abortion gives the mother, I guess you wouldn't say mother, the female, the right to make that decision. I can't be a mom if you don't have a kid, dude.
But then if abortion is taken as the murder of a child, then the child exists since conception, then the mother is always a mother.
I think under Catholicism that's not correct, but okay. Yeah, this is a legal argument.
I'm an atheist.
The pregnant woman? Can we agree on that one? Okay, so the right to abortion that the pregnant woman would have is not an entrenched right like those other entrenched rights, because the right to abortion creates this critical moral question. So in other words, they're setting up that, yeah, we agree they're entrenched rights that are protected by precedences, but they never talked about killing kids. That's why they're entrenched. Yours is distinguished, and we can't support that. And there is no precedent to support that, which they're correct. So that was the first 9 pages of the holding. Now, specifically about the Judge Alito opinion, he cited a different United States Supreme Court case, and he said the goal of preventing abortion does not constitutionally individualize discriminatory animus against the woman. So he wanted to make it clear under the Brave versus Alexandra's Women's Health Clinic, 506 U.S. 263 and 273 and 274. Basically, we don't have any animus. We don't want to discriminate. We don't have any hate. We don't have any bad feelings. But if we're going to prevent abortion because it doesn't fall under the Constitution, we're not doing this to discriminate against women. So he just wanted to put that precedent out there that the court never intended to discriminate in that way. But that the right to abortion is not deeply rooted in the nation's history and traditions. On the contrary, an unbroken tradition of prohibiting abortion on the pain of criminal punishment persisted from the earliest days of common law until 1973. Okay, so this is going to be a little bit disjointed because I'm summarizing about 60 pages worth of stuff. So I'm going to be talking about bringing up talking points from the Justice Alito opinion and not necessarily analysis. The analysis is done. Okay?
So I do have one question.
Sure.
So and this goes for many laws, I'm sure, and this analysis is really good. Thank you. This is very informative. It's also chilling in its implication.
Yes.
But so if we take the abortion has been illegal practically until 1973 and has a storied history of being illegal, at what point is there enough precedence to grant legality to something? And I mean, you could easily make the argument that the amount of time that a black person has been unable to vote in government affairs exceeds the amount of time they have been able to, and therefore legal precedent establishes their second-class citizenship. And you can do this for a number of things. You can easily apply it to my marriage,
which they do.
So, that's a scary road to go down. And I know that Clarence Thomas was blasted in the news for openly discussing that exact thing.
Yep. I think you are giving precedent. I don't want to say too much weight, but think of it more as a linchpin, right?
Okay.
In this case, there were 2, Casey and Roe v. Wade, right?
Yeah.
Once you uncork or remove those linchpins, there's no precedence.
But you have practice.
You do.
So that's your legal precedent, but now you've established a societal practice since 1973, so almost 50 years.
Right. So now you're talking about the history and tradition.
Yeah.
Precedents.
Yeah, sorry.
Okay.
Yeah. So and I'm obviously not a lawyer, and this is my first foray into a lot of these terms.
I hate parsing the words like that, but you gotta.
No. And that's your thing. That is a large part of your profession is parsing words, and words matter. So no, I appreciate it. But this gets into the history and the entrenchment, the tradition.
They do not give a bright red line rule about that. So that means a couple things. One, the judges are going to get to determine whatever they want. I would think a safe harbor to propose what that would mean is numerical. Meaning, if there's 50 years of it, but then there's 70 years of there not being it, where is the rooted history and tradition? Now, is a court going to be that reasonable and fair? It depends on whether it's the conservative court or the liberal court and what they want to hold. This is where the judicial activism and, ruling with your heart as opposed to your mind comes in. Again, I read nothing that gave me an ordered or numbered or a definition of how to determine whether numerically is there enough history and tradition. So in the current case with Roe v. Wade, you're right, until the 70s, there were two Supreme Court cases, and I'm sure there was some periphery cases out there, but you had those two major linchpins, and then you had now would be about 50 years of women's rights. But he went back to the 1800s, right? And he pulled, and he cited a lot of decisions talking about how it was criminal in nature to have an abortion. When you have all those laws on the book.
But that's a bit cute, isn't it, though? I mean, obviously he's a Supreme Court justice. He's smarter and more storied than I ever could be. But just on its face, that's a bit of a logic trick. Because if I go back 5,000 years, I can disprove atomic theory.
Sure.
So,
question.
Yeah.
Under that scientific lens, do you adhere to the rules and the research methods that they used back then? And would it be, for lack of a better term, canon of the current understanding of atomic theory?
Well, it's only canon when Disney says it's canon.
Okay. Bastards.
Well, atomic theory didn't exist until the late 1800s. So, well, actually, Aristotle's the first one that says atom. That's where the name comes from. But he didn't mean it like we mean it. But the methods of analysis and observation they used 5,000 years ago are quite literally ancient. So I take your point.
Yeah, my point it's technically not cute. There's a thing in English majors all around do, but they never say. If they want to make an argument, they're going to find the quotes that are going to suit their argument. I'm sure you do that.
I have some news for you about how research articles are built.
Yeah. So,
but no,
this.
But in that you could. So cute. That's a disingenuous term. I should have. But I can, if I'm going to make an argument, legal or otherwise, I can sort of set the goalposts a little bit.
Yeah, cherry pick.
Not even cherry pick. I can, if it's 1874, in which a decision that supports my case, and then there's a lot of afterward, but there's this one in 1871 that really goes against it, I'll start in 1873.
So in the legal profession, and you're going to laugh at this. Great. It's going to be a good one, everybody.
Great.
It's almost like an honor system. And here's what I mean. Not that lawyers are honorable. I'll be the first one to say they're not.
People aren't honorable.
When using citations, when using what they call points in authority, it is the attorney's duty to be forthright and honest that they're giving valid points of authority, meaning cases that are still valid and the precedents, and to not hide contrary cases. And it's totally an honor system. And totally up to whether the judge and his legal clerk, law clerk is going to do the research to find out what really are the points of authority. And it's counsel's job to submit their brief to argue their points of authority for all the cases that suit what they want to argue. So usually you get a blend of the two arguments going back and forth. But if there's like some major case law that we all agree that, oh, you have this right under a contract, or, oh, case law establishes this under a contract, then yeah, both parties are going to argue it or acknowledge it and then move on. Here is, I guess, the unfairness of this situation. The Supreme Court absolutely gets to cherry pick their arguments and what laws they're going to review. We hope they're going to be honest because there is going to be a dissenting opinion, and these things aren't written over the weekend. They're passed back and forth. Everybody reads it. I mean, didn't the news leak come out 3 months before it was published? Right. So they all know what's coming out. They have their drafts. And then the other side is going to get to respond to all this argument. And this is where I fall short. I should have read the dissenting opinions. I heard they weren't that good. And it was another 170 pages. So I didn't read them. Maybe Sotomayor did discuss the interpretation of Entrenched or Justice Alito being cute by looking back into the 1900s and 1800s of these laws. But there were means to correct or offset. And the unfairness of this process is the buck stops here. That's what a judge is supposed to do in their ruling, is to give the justification, and they're supposed to give the reasons or the analysis of their justification and their citations, which he did. He did his job, whether you agree with it or not, whether he cherry-picked or not. He's still following the same rules that he used to analyze Roe and Casey. Does that make sense?
It does. No, you've presented a very logical path that the
that hurt.
justices. No. I'm serious. I'm not saying this tongue in cheek. I'm not being facetious in any way. This has been very illuminating for me. You've taken me. I know nothing about law, obviously, and you've taken me right through sort of the history of Roe v. Wade. Casey, didn't even know that existed. I'm learning fun new terms, and even though I can't recite it back to you, obviously, I have a much better understanding than I did an hour and 25 minutes ago about this case. And because of that, I think its implications are far more chilling, and I'm that much more disgusted by it.
You just wait.
And I am more truly appalled than I was before.
So I will definitely discuss it in the second point, because we're specifically going to talk about gay marriage. And I don't know if they call it the right to homosexuality, but they just determine homosexuality.
Sodomy laws.
They didn't cite those, but I'm positive they're littered in the prior decisions. But let's get back to it. So, okay. Now to get back to the last 2 points, and we have a little bit of Justice Thomas. But the last 2 points Alito makes, very interesting from a morality point. I will make this argument. Abortion hits different demographics and different socioeconomic classes. A lot of people argue, well, why don't these women give their kids up to adoption? I always thought there's not enough people around to adopt all these kids. And quite frankly, certain kids are undesirable because of their age, because of their medical history. And I'm sorry I'm calling them undesirable. I'm saying unadoptable.
So having been through the adoption process, when we were first trying to have a child, it's actually a little even more grotesque than that.
Sure.
So, and it's legitimate to say undesirable because you're not talking about your personal desire or even the attractiveness of that term. It is an economic thing, which is even more disgusting in a way.
And an ethnic thing, let's be honest.
And that's that is the first criterion upon which people are separated. I shouldn't say people, upon which children are separated. So when you go to the adoption agency or when you go to the adoption meeting, you have people that have most likely adoptive parents, and they go through like the program and everything and how it works and what the experience is going to be like. And they also talk to you about the financial constraints. If you want to adopt a white baby, it's a longer waiting list and it's expensive. If you want to adopt an Asian baby, it's not as long a waiting list and it's not as expensive. If you want to adopt a Latino baby, it's an even shorter waiting list and it's not as expensive. And if you want to adopt a black baby, it's a pretty short waiting list and you get financial incentive. It's not just that it's not as expensive, it's that it is financially beneficial.
Do they have...
Notwithstanding the cost of having a child.
Do they have a pie chart?
Fucking disgusting.
Sorry. Yes, that is well, it's realistic. That is the worst part and why it's disgusting.
Yes, thank you. But just imagine sitting there and seeing humanity classified in that manner.
Trying to keep a straight face.
Well, I mean, straight in terms of being politely
with not
horrified.
having your mouth drop out of the floor when they're telling you that.
Yeah.
I mean, if you look at and people do not like to talk about this. I don't care. I'm brown. I'm from the ghetto. This is all we talked about. If you look at the pie chart of the amount of kids who need to be adopted and where they come from, and that typically people who adopt usually want to adopt same ethnicity as their kids because they don't want to answer all those questions at the park, there is a complete offset or unbalance about the number of kids who want to be adopted and who's doing the adopting. There's angels and saints out there, but let's talk statistics here. Statistically, you got a lot of these Midwest Christians that are white that are adopting all these babies. I also think, personally, from what I've seen, it seems to be that white people are having trouble having babies at the older years, and because so many white people are going to college, they're delaying their family planning. And so there just seems to be this dynamic here so that adoption is more prominent. Now, I could be wrong. Please in the comments or wherever, post this stuff because I would totally like to see these statistics.
Bro, of all the things you're going to get comments for in this podcast, that's probably not the one.
Fair enough. So, interestingly, and the reason why I just stepped in it is Judge Alito pointed something out that I never knew about. He said that states have increasing adoptive safe haven laws, which generally allow women to drop off babies anonymously. I always thought this was crazy, and that a woman who puts her newborn up for adoption today has little reason to fear the baby will not find a suitable home. I called bullshit. He cites a CDC adoption experiences of women and men that demand for children to adopt by women 18 to 44 years of age in the U.S. In 2002, 1 million women were seeking to adopt children, whereas the domestic supply of infants relinquished at birth or within the first month of life and available to be adopted had become virtually non-existent. So you have 1 million women looking to adopt, whatever the ethnicity, whatever the socioeconomic status, and they couldn't find babies. Now, I'm sure you can comment more about this than I can. In the adoption process, I'm sure they have kids from 0 to 6, 0 to teenage.
To be honest with you, we didn't go that far past that.
So it was something you funneled criteria out of? In other words, you were looking at youngers?
Well,
like when they gave you the catalog to look at all the kids.
No, it's not quite like that. Or it may be like that. I wouldn't know. We didn't go to enough. We went to 2 different agencies, and we sat through the presentations with other potential parents or intended parents. And after 2 experiences, like the one I described, as to say nothing of the cost not being all that much cheaper than surrogacy, we're like, I don't think this is for us.
That's completely fair. That is completely fair. I've heard adoption. I've known a couple of people who've adopted, and they said it's a brutal process. The highs and the lows, especially. You think you're going to get the kid, and you're not.
Yep.
And then I pray that no one's in that situation. But unfortunately, a lot of people are. So anyways, these 1 million people who are in that situation couldn't find the babies. Now, from my experience with the adoption process, which is not much, most of those kids are for relocation, for lack of better terms. They come from problem families, and a lot of them were taken away as opposed to given away. So it's usually a harder find, usually foster parents and not adoptive parents. But sad situation. God bless all of them. God bless those angels who are willing to adopt and foster. Okay, so now for the really, really scary part. Remember how we talked about those entrenched rights that are protected in other precedences? Judge Alito specifically talks about them. He talks about the case Griswold, which talks about the entrenched right to contraception. Lawrence, which is the entrenched right for sexual conduct with members of the same sex. And Obergefell, which is the entrenched right to same-sex marriage. In all of those 3 decisions, they were based upon the entrenched rights supported by other precedences, which means not the 14th Amendment, right to liberty, not this right to privacy, not substantive due process clause. We're talking about an entrenched right supported by other precedences. In those 3 cases, the contraception, sexual conduct with members of the same sex, and Obergefell, Alito was saying those 3 are entrenched and have precedents that are backing them up. Casey and Roe do not. And why don't they? The decision is distinguished because the exercise of the rights at issue in Griswold, he named some other one, Einstein, I believe it's a German name, Lawrence and Obergefell, does not destroy a potential right, but the abortion has that effect. Nothing in this opinion should be understood to cast doubt on precedences that do not concern abortion. Each decision is subject to its own stare decisis analysis, and the factors that our doctrine instructs us to consider, like reliance and workability, are different from these cases than for our abortion jurisprudence. So in the Alito opinion, he's actually trying to protect the right to contraception, Griswold, sexual conduct with members of the same sex, Lawrence, and Obergefell, which is the same-sex marriage. So he's actually kind of putting that extra layer and saying, for wrong or right, I mean, it sucks for Casey, right to abortion, but he's saying, yeah, right to abortion, there's no moral stance because it destroys a life. We don't have those moral questions. There's no life being destroyed in contraception because apparently it's not a life yet. Non-Catholic viewpoint, but we can get back into that argument of when does life start. He's going to make this argument that contraception does not prevent that. Sexual conduct with a member of the same sex, hey, have fun. You're not hurting anybody. Same-sex marriage, you're stupid. Join us. None of that has that big question of whether a life is ending because of it. Any questions so far? And then we'll jump into Justice Thomas, and I think we'll call it a day.
Yeah, there's only so much bile I can swallow.
I apologize. All right, so...
No. It's you didn't make the ruling.
Yeah. Justice Thomas. I'll have about 3 parts here. All right. So first, he says the decision does not affect the precedents of the other cases, such as Lawrence, Obergefell, and Griswold, because abortion cases are unique. But because all those other cases are based on substantive due process precedents, which is demonstrably erroneous, he suggests that the court should reconsider these cases. So that's where he got lambasted. So what Alito did is he said, all right, you have some entrenched rights. Let me read it one more time. You have entrenched rights that are supported by other precedences, and that is the Griswold, the Lawrence, and the Obergefell case. What Justice Thomas disagrees with him, and he says, nah, Lawrence, Obergefell, and Griswold, yeah, they're different than the abortion case in Casey, but they weren't based on entrenched rights. Sure, they had precedents, but not entrenched rights. They fell under the 14th Amendment substantive due process precedent. And I don't think those substantive due process rights, yeah, they're kind of vague in general. So we should look at Obergefell, Lawrence, and Griswold again. So he opened the door. He didn't, and let me be clear, we know what he's going to decide if he gets those cases. We absolutely know what he's going to decide, and it's a conservative Supreme Court. But it's going to require that 5-point prong analysis of how to overrule precedent, and they're going to have to dismantle and show why those rights, contraception, sexual conduct with members of same sex, and same-sex marriage, do not fall under substantive due process precedents. Let me finish these last 2 points before you lambast him. All right. Justice Thomas goes on to say, substantive due process is the core inspiration for many of the court's constitutional unmoored, I like that, unmoored policy judgments. Substantive due process is often wielded to disastrous ends. Gamble 586 U.S. How the court identifies those fundamental rights protected via the due process clause involves policymaking rather than neutral legal analysis. So, Justice Thomas makes it very clear. Yeah, due process is unmoored policy judgments. When the court uses it, it comes to disastrous ends. So we know if given a chance, he would overrule Lawrence, Obergefell, and Griswold. And he says that when reviewing the protected rights under the substantive due process clause, we should use neutral legal analysis. So he thinks he's being neutral and fair-minded. And that's where I stopped and I went, yeah, I'm good. I think I got it. So yes, scary. So here's what I would foresee. There would have to be court cases that would have to be filed and the appeals, and it would have to get to the Supreme Court. So Judge Thomas wouldn't get his hands on any type of appeal that dealt with Lawrence, Obergefell, and Griswold 4 or 5 years. So we would definitely see it coming down the pipe if it ever became an issue.
Yeah, but that doesn't dispel the fear.
Of course not. Of course not.
I mean, the overturning of Roe v. Wade is a decades-long, very calculated, very measured attack that resulted in success for that faction of society that believes abortion should be illegal. Thank you very much for your analysis. It's very informative. Yeah, but
it's a pretty solid decision.
Anything that I say again?
It's a pretty solid decision. My only issue with it was how they distinguished based on morality, that moral question. That was where I was like, yeah, you guys are extending a bit.
Well, unfortunately, so I see the legal analysis. I see the legal reasoning behind it, which I did not before. Thank you. I think my opinion is somewhat meaningless since I'm not a lawyer. And
yeah, but you might be the voice of others, because I just shoveled a lot of crap on people.
I can do nothing but fear for the implications this has, the precedents that it sets, the precedent that it provides. And, you know, that's 2, 3, 5, 10 years from now. For right now, there are going to be a lot of children born into a world that does not want them. To a lot of parents and mothers that maybe shouldn't have had them. There's going to be a lot more heartbreak. Statistically, there is more heartbreak in countries that outlaw abortion, specifically concerning infants, newborns, mothers, than there is in countries that do not. And it's going to be a long road and a dark place.
It's going to be a shit show, I think is the appropriate term. There's going to be
It's
jurisdiction shopping. People are going to be going and getting, the backstreet medical treatments.
Mm-hmm.
They're going to be, the ones with money are going to be able to go out of state. But let's be honest here about the topic of abortion. It is a lower socioeconomic problem. And those are the people who have the least amount of education on this topic and the smallest support network. And those are the people who often need it.
Well, that's the thing. Like, the data in aggregate are beyond compelling. The existence of contraception, and actually it's almost ironic. So the existence of and availability of contraception and sex education dramatically decreases the need for abortion.
Of course.
Because there's so many fewer pregnancies that are unwanted. So if you really wanted to take a bite out of abortion and abortion rates, you'd increase sex education and contraceptive availability. However, the states that are most vehemently opposed to abortion are those precise ones, not in all cases, but in most, that do not fund sex education and want to rescind contraceptive availability. It is fucking maddening. And caught in the crossfire of all of this are women first and baby second.
Yeah, this is not a defense, but I do understand that this is a spider web, meaning who provides the most amount of contraception in these areas. Planned Parenthood. Planned Parenthood also provides abortions. Lawmakers.
They do, but 97% of what Planned Parenthood does has nothing to do with abortions.
But when you're giving them one lot of money, and you don't get an accounting of what goes to what, and you have a moral reason for why you might want to keep. I'm not saying I agree with it, but I'm saying I get it.
No.
And I wish they could be adults, sit down at the table, and make those things like, hey, we're going to give you the 90% of funding. You need to give us your audit. You need to do this. You need to meet these certain rules. Maybe they do that.
I think they do.
I would assume, but you never know, man. These are political institutions.
They're audited pretty heavily. They are, but so I don't know. This is a very
I really fear for the next generation and the problems that are going to occur.
Our kids.
Yeah.
Your daughter, my daughter.
Yeah. But we're blessed that we have our kids. I think it's tragic that some people don't, whether it's for reasons of their own making or not. It is a sad case. It is a heavy topic. I thank you for sticking with us, for me reading, stumbling, repeating a lot of things. Hopefully the analysis was clear as mud. Jesus Christ, man, we went an hour 50. I'm pretty sure they fell asleep.
Well, I read John Grisham's A Time to Kill last week, so I'm practically a lawyer now, so I understood everything.
So, any questions? I will not be able.
I also watched The Firm.
Go ahead.
I said I also watched The Firm.
The Firm,
so,
yeah.
I mean,
Law and Order. I think that's the last thing you need, and you have the Crim Pro behind you.
That's a good point.
Yeah,
that's a good point.
Any comments, questions, or concerns? Do not address them to me. I will not be answering these because I want to distance myself from this topic. And good luck. Hopefully, if you want one, you can be in a blue state and you can get one in the express lane. I don't know what else to say. Any parting words from you, Fighter2Wizard?
Nope. I didn't speak much on this because I don't have the educational standing to do so, and I'm pretty much stunned speechless when starting from last week to this, and everything I've read and all the things I've listened to and especially this, which has been an excellent explanation and analysis. Thank you. Have done nothing but solidify my opinion that that this is going to be a very dark time.
Yeah.
For a lot of women and a lot of children and a lot of families.
I'm positive they're already launching their challenges, but how long is it going to take? It's going to be
a lot of human lives that are caught in the crossfire while they're challenges. Yeah.
All right, everybody, have a great day. We'll see you next time.
Yeah, that's a real nice ending there. Toodaloo, y'all.
Hey, what's going on, guys? This is Raiderlance one more time, just to do a quick little wrap up, put a bow on this long episode, and tell you a little bit about my thoughts. So we went through the full analysis of the Dobbs case and how they found that abortion is unconstitutional at the federal level. We also went through a couple of the justices' opinions. We did not go through the dissenting opinion. That could be its own show. I don't think I would necessarily agree with it, but I haven't read enough about it. So I could be completely wrong. Now, what is important here? In my opinion, as an attorney, of course, you need to read the laws, you need to read the decision, and you need to analyze the arguments without emotion. Compartmentalize it. You can believe what you believe. You can have the moral stances that you have. That's not going to help you when you're looking at the plain text of the law and statutory interpretation and, all that stuff. You need to just be a robot when reading this so you can understand it, see what the arguments are. So then you can create your own counter argument if you deem so. Now, whether you are pro-life, pro-choice, in my opinion, this is more specifically for the pro-choice people. I think attacking this decision is not the best avenue. It is a solid decision. In my opinion, it is the correct legal decision. Whether I agree with it morally or not, whether I like it or not, it does not matter. It is a solid legal decision. As part of being a lawyer, I also look at the different legal ramifications. And here's what I mean. Some people say, well, there's only conservative judges. We need to pack the court and bring in a bunch of liberal judges so that we can outnumber the judges and do a new decision to make abortion legal again. That is a tremendously horrible idea. One, because the major counterpoint to liberals and pro-choice people is that the current conservative judges are being activist judges. Well, if you pack the court and dump in a bunch of liberal judges and expand the number of the justices on the Supreme Court, you're doing the exact same thing. And it's just going to be a one-upmanship, if that makes sense. There is a much better way to do this. First, is to realize that each state is going to come up with their own decision about abortion. Now, I know the argument, I have to travel for medical care. Each state should allow it, especially in some extenuating circumstances. Then that is something you take up with your state legislator. Additionally, you can amend the Constitution to make abortion legal at the federal level. I'm not saying it's easy. I'm not saying that there won't be a lot of work or there won't be pushback from 50% of this country. But we have better avenues than to be petty, than to deteriorate the current legal system that we have. So, in a nutshell, wherever you stand on this, I think we should all come together and acknowledge that this country has a pretty good legal system based on the constitutions and the courts upholding or rejecting certain decisions. And I'm not so sure that just throwing it away by packing the courts is the best idea. So just be careful what you're proposing. Make better legal arguments. You can have whatever opinions you want. I personally don't care. But hopefully, if you were offended, you accept being offended and that we don't care. We were just doing a objective legal analysis. But either way, if you find this important, please share it. Please give it out to people so that they're not arguing from their feelings about this decision and its outcome. Let them at least talk from an educated and knowledgeable situation, actually knowing and understanding the law. So that's my little rant. Catch you next time. That's it. That's our show. This is an important discussion, so thank you for sticking it out with us to the end. We would love to hear whether we did a good or bad job presenting this information. Please do us a favor and like, subscribe, share this podcast so we can get some traction. Once I get around to it, check us out on our socials. Combative Nerds on Patreon, Instagram, Facebook, LinkedIn. You know the deal. Thanks for hanging out, and we'll see you next episode.